Hello, landlord. So today I want to talk to you about a particular statute that you might be familiar with. It comes out of the Texas Property Code, Chapter 92. I want to talk to you about what your obligations are to your tenant when it comes to repairs. Let's get started. Welcome to my YouTube channel. I've been helping clients for over a decade, and now I'm coming straight to you. To get even more great videos, click our links to like and subscribe. Stay in touch by phone, text, email, or on our highly interactive Facebook group, Texas Landlords. And now, Ernie talks. So if you have a written lease, you may have noticed that in the repair section, there's a section that describes to both you and your tenant the duties and obligations of a landlord when it comes to repairs. That section should have a provision in either bold or underlined print that describes the rights and the duties that pertain to both the landlord and the tenant regarding repairs. That comes out of section 92.056 of the Texas Property Code. Now, the Property Code will explain to both the tenant and the landlord what the law expects out of the parties when it comes to all sorts of things. The Property Code is very good at laying out what courts and the legislature have decided are fair play between the two parties to this written agreement. Among these is the duty of a landlord to make certain repairs. In particular, repairs that affect the health and safety of an ordinary tenant. So naturally, we could go on and on about the duties that are created when a tenant breaks something. And so those repairs are different than other kinds of repairs. Additionally, cosmetic repairs are different than the kinds of repairs we're talking about today. Today we're talking about defects on the premises, again, that affect the health and safety of an ordinary tenant. We're not really going to get into examples of these kinds of defects because there is no bright line test for it. Essentially, what you have to use is your powers of reasonability. And so is it reasonable to believe that the defect that you are faced with affects the health and safety of an ordinary tenant? Essentially, that's the test that a court will go through. And so it's the test that you should go through when you're faced with a repair request. So the Property Code requires a very specific set of procedures for landlords and tenants involved in a written lease. If there is a written lease, the request for repairs must be made in writing. The first request should be sent to the landlord from the tenant in writing at the place designated in the lease. If you have a lease and there is no specific designation, you should add that. Unfortunately, if you leave this ambiguous, then you give a lot of latitude to the tenant in terms of delivery of this notice. Have a specific place where these notices can be delivered, whether that's by regular mail, by email, by fax. Some people are fine with text. My suggestion would be regular mail, fax, and email. So make sure that you have a designated place where you receive notices from your tenant, particularly those having to do with repairs. Now, what the code requires is that the repair be made within a reasonable amount of time. Generally speaking, if you go beyond a week, you exceed what the court generally for a regular repair is going to be reasonable. However, certain repairs naturally are going to take longer, especially if we think in terms of a natural disaster of some sort. Replacing a roof may or may not be feasible, particularly when a given area has lots of work going on at the same time. The point that you have to observe as a landlord is the issue of being reasonable and diligent with your attempt to remedy the situation. Now, I get asked often, well, to what degree do I need to make the repair, or at what standard of quality do I need? Again, it's a reasonable standard. And so if the toilet breaks and absolutely your tenant is going to need a toilet, you don't have to get the top of the line solid gold toilet. A standard, normal use, regular run-of-the-mill toilet is just fine. Now, what you don't want to get is something that's 30 years old and already cracked and heavily used. Uh, if it's not a reasonable manner of repair, the court's going to find it not suitable and will likely employ one of the remedies available to the tenant, which we'll get to in a bit. So first and foremost, you want to make sure that you've taken care of the repair within a reasonable amount of time and that you've handled the repair with reasonable diligence and that the service that you've delivered itself has been reasonable. Well, what happens if you have failed in any of those respects? Well, the rights of the tenant then are to give you a second written request for repair. And in this second request, the tenant can elect a remedy. Specifically, the tenant can request one of the remedies allowed under 92.056. The tenant can say, if you fail to remedy this defect within a reasonable amount of time, I then will hire somebody to do the repair for me, and I will pay them and deduct that amount from next month's rent. Now, this presupposes that the tenant is current on the current month's rent. That's an absolute. There is no remedy that will allow the tenant to skip a month's rent while they are waiting for a repair. Next, the tenant can elect to simply sue you and say, if you fail to make the repair within a reasonable amount of time after this second written request, then I will file a repair and remedy lawsuit against you in the justice court and have the court order you to make this repair. And in that request, in that lawsuit, the tenant can recover all reasonable necessary attorney fees and court costs. The final option that a tenant would have is to unilaterally terminate the lease at the end of the current month which has been paid. So if, for example, I'm sending the notice, the second notice for a request for repair, and in that notice I say, look, I'm going to give you another 7 days to make this repair. If you're unable to do it at the end of this month, for which I am fully paid, I will simply leave. I'll terminate the lease and walk away from this unit. So what you have to consider as a landlord is, if you have a tenant who has sent you these written notices and is current on their rent, they have a strong case against you for making a repair. Now, my recommendation always for landlords is, if you get a request for repair, it's always best for you to handle that request. You certainly don't want your house to fall into disrepair because you don't have the time to get around to this repair. Recognize that if the repair itself affects the health and safety of an ordinary tenant, you are obligated to complete that repair. And if the tenant follows through with this procedure that's lined out in Chapter 92 of the Texas Property Code, you could be on the hook for all of the tenant's attorney's fees and court costs, as well as certain statutory damages if the court finds in favor of the tenant. If you have a question about a repair request that has been made to you, don't hesitate to send me an email, send me a text. You can make a comment down below. I'd be happy to answer your questions. Until next time, happy leasing. If you enjoyed this video, we invite you to like and subscribe. Follow our links to even more great content. We're always adding to this collection. If you have a video topic you'd like to see, comment below.